Hi, I'm Ron Zimmet with the Daytona Beach law firm Zimmet and Quarles. We do nursing home litigation for nursing home malpractice. Do you have the right to see nursing home medical records? One of the things our nursing home malpractice clients tell us all the time is that they ask the nursing home to let them look at the medical records, but the nurses or administrator would not allow it. Usually, our clients are acting as a healthcare surrogate or as a power of attorney for one of their family members in the nursing home. When a nursing home denies access to records, it is clearly violating Florida law. The nursing home resident, a healthcare surrogate, and a person acting under a power of attorney have unambiguous rights both to see the records and to copies of the records. If a nursing home denies you access to medical records, make a copy of the answer that we posted in our frequently asked questions section of our website, zqlawyers.com, and give it to the nursing home administrator with a written request for access to the records. Make a note about what the administrator says in response. Here's what the Florida statutes say about access to medical records, and these are the law in Florida. Section 400.145 of the Florida statutes regulating nursing homes provides that the nursing home shall, and by the way that's mandatory, shall furnish to the spouse, guardian, surrogate, proxy, or attorney-in-fact of a current resident within 7 working days after receipt of a written request, or of a former resident within 10 working days after receipt of a written request, a copy of that resident's records, which are in the possession of the facility. This statute also gives you the right to look at the original records. Here's what it says. The facility shall further allow any such spouse, guardian, surrogate, proxy, or attorney-in-fact to examine the original records in its possession. That's an exact quote. The statute governing healthcare surrogates gives the surrogate the right to medical records. Section 765.205 Florida statute says the following. The surrogate, in accordance with the principal's instructions, that's the nursing home resident, by the way, unless such authority has been expressly limited by the principal, shall be provided access to the appropriate medical records of the principal. That's the nursing home resident once again. Nursing home residents, of course, have the right to be treated by a doctor, and the law also gives you the right of access to the doctor's medical records. Section 456.05 Florida statute says the following, quote, any healthcare practitioner shall, upon request of the person, that is the patient, or the person's legal representative, furnish in a timely manner, without delays for legal review, copies of all reports and records relating to such examination or treatment. There is an exception for psychiatric records. So, don't believe any healthcare provider. Don't believe a nursing home administrator. Don't believe a nursing home nurse if they tell you that you don't have a right to see the record. You do have the right. We've got a copy of this transcript on our website at zqlawyers.com. All you have to do is copy and paste it, give a copy to the nursing home administrator, and you have a right to see those records. If there's a problem with it, we're happy to answer questions. And for now, however, I'm Ron Zimmet of Zimmet & Quarles. Thanks for listening.